But Biden fought against these lawsuits the same way Trump did. And he made the same legal arguments against the ERA. So women were kind of flummoxed, like, which party is on our side? And the answer was neither.
Welcome back to Real Clear Politics on Sirius XM. I'm Andrew Walworth, and our next guest is Wendy Murphy. She is a law professor at New England Law Boston and a columnist at the Boston Herald. Wendy, welcome to the program.
Great to be with you, Andrew.
So I wanted to talk to you today because you have this really interesting piece that ran in the Herald about something Joe Biden said and did as he was leaving office. This was on Friday, January 17th. It was an address to the U.S. Conference of Mayors, and I'm just going to play it for you and get your reaction.
I affirm the Equal Rights Amendment to have cleared all the necessary hurdles to be added to the U.S. Constitution now. The Equal Rights Amendment is the law of the land now. It's the 28th Amendment to the Constitution now.
So pretty bold constitutional gambit, I suppose. But you argue in your article that it actually hurts the chances of the ERA ever becoming law. Explain that.
Yeah, I mean, if only yelling made it so, right? First of all, I don't think anybody who's being honest agrees that the president has the power to declare a constitutional amendment valid. And that really raised a lot of red flags for people because there had been a push for Joe Biden to direct the United States Archivist to put the Equal Rights Amendment in the Constitution, which he does have the power to do under Article 2, the so-called Take Care Clause. And he declined to do that. He refused to do that. But let me back up a little bit and just give everybody a context. The Equal Rights Amendment was filed in the early 1900s with Congress as an amendment to the Constitution because in 1865, when the 14th Amendment was adopted and granted equal protection of the laws to all persons, women weren't included. We learned that through a variety of Supreme Court decisions over the years that followed. So we knew we had to go to Congress with our own amendment to basically fix the 14th Amendment. And that's what we did. I mean, that's really what the ERA provides. And the first time it was filed in 1923. It had slightly different language, but the ERA today says it's very simple. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So it's really very simple. Even though it was filed in 1923, it didn't pass Congress until 1972. And then, of course, we all know under Article 5 of the Constitution, an amendment has to be then ratified by 3/4 of the states. The problem is a deadline was attached to it. It was 7 years, later extended to 10. And by the end of that deadline, we had only reached 35 of 38 states. So everybody assumed it died. Then something really interesting happened, which is the 27th Amendment was adopted in 1992. And that amendment didn't have a deadline, but it was given 203 years to ratify because it had been passed by Congress in 1789. And women cried foul. I mean, they basically said, we're not going to go start over. We're going to go get the other 3 states, and then we're going to argue in court that you can't have such a frivolous constitution that some amendments get 2 centuries and others get a handful of years. And that's what we did. And then we got a lot of support in 2012 when the United States Archivist issued a public statement saying, if women get 3 more states to ratify, I will put it in the Constitution. So we were really excited. We went to Nevada in 2017 and got it there. We got ratified in Illinois in 2018, and Virginia, the last state to ratify, in 2020. But guess what happened? The archivist reneged and said, I'm not putting it in the Constitution. Well,
so just so people get this straight, so 2023, the 38th state, Virginia, passed it.
2020,
I'm sorry. And at that point, there's still a question of whether or not it becomes constitutional law, right?
Well, right. There's a reasonable debate about whether the deadline is valid. And we had a good argument that it's not valid. And many constitutional scholars agreed with us. Not all, but some disagreed. And so we had a reasonable argument. We wanted to go to court and hash that out. But in order to even have a legitimate debate, we had to get it into the Constitution. We had to get the archivist to do his job, especially where he had promised to do that. And he said in 2012, it's not my job to decide whether the deadline is valid. My job is to put it in the Constitution. It's a mandatory, non-discretionary duty It's a ministerial act. I have to do it. And if people want to go to court and fight about it, that's their business. And in the history of this country, no archivist had ever refused to put an amendment into the Constitution, even when there were legitimate debates about the validity of an amendment, like the 14th Amendment. There were some states that rescinded, so there weren't enough that had ratified by the time it was put into the Constitution. And the reason that was okay is because the Supreme Court ruled many years ago that an amendment becomes valid the moment the last necessary state ratifies. So we were confident the ERA was valid, but we needed this ministerial task to take place so that when we got to court, we could say, look, it's in there. Now we need to debate, what to do with it. And yet the archivist refused to put it in. And then it was interesting because Trump was in office at that time. And a lot of women said, well, it's Trump's problem. This is a left-right issue. So let's just vote for Joe Biden. And once he gets in, he will unblock the ERA. He will tell the archivist to put the ERA in the Constitution. And that didn't happen.
Let me just stop you right there. I just want to tell people you're listening to Sirius XM. I'm Andrew Walworth. I've got Wendy Murphy with me. We're talking about the ERA. So why, I'm just curious, when the president on his really last day in office, it was the Friday before Trump's inauguration, declares that the ERA is law land. Why is that not good news for the cause?
Well, again, it sounds good if you know nothing about how amendments happen, because the chief executive official in the country who is tasked with ensuring enforcement of laws declares the ERA valid. The problem is this is not a kingdom. He doesn't have that authority. And it's very clear in the Constitution that the president can't declare an amendment valid. And there's no basis for what the president did. So really the question for me was, why would he do it? And why would he do it on his way out? Because again, just hearkening back to what happened when Virginia ratified, when the archivist reneged and failed to put the ERA in the Constitution as he promised he would, I sued him in federal court in Massachusetts. And then a couple of weeks later, another lawsuit was filed against him in DC federal court by the last 3 states to ratify. We both litigated these cases for several years, and they were still being litigated when Biden came to office in 2021. But Biden fought against these lawsuits the same way Trump did. And he made the same legal arguments against the ERA. So women were kind of flummoxed, like, which party is on our side? And the answer was neither. We still kept pushing Biden to get the ERA into the Constitution. And that kind of came to fruition toward the end of his term when he announced, as you described in the beginning, I now declare the ERA valid. Now, of course, we thought, well, why would you do this 4 years later after fighting against 2 lawsuits? 2 lawsuits your Department of Justice fought viciously the same way Trump did. Where is this coming from? And why didn't anybody in the media ask him, well, how does this relate to your opposition to the ERA in 2 federal lawsuits? And by the way, you didn't direct the archivist to publish the ERA. Why is that? Nobody asked him these questions. So for somebody like me, I'm really trying to watch this as a chess game. And it looked problematic enough to me that I started to pull back a little bit and look at the big picture, most importantly, focusing on what cases the Supreme Court is currently reviewing.
And that brings us to Skrmetti, which I want to get to, right?
Exactly. So United States versus Skrmetti is a case that comes from Tennessee. Tennessee in 2023 passed a law prohibiting the use of gender transforming medical events to help a female turn into a male and vice versa. So you can't give them puberty blockers, surgeries, and so forth, not children. The Justice Department, on behalf of Biden, sued Tennessee, and that case was fast-tracked to the Supreme Court. Oral arguments were held last October. Well, very interesting in that case, the advocates, including Biden's Department of Justice, didn't argue that the ERA was valid even though they take the position that the ERA does apply to transgenderism because transgender is covered by the word sex. And as I told you with the language of the ERA, the word sex is in the ERA. Well, the transgender people not having their own constitutional category, if you will, filed their case with the Supreme Court saying that law discriminates against us based on sex because transgender is part of sex. And
so I mean, that's what I think is what's so interesting about your piece. It's what I think what you're arguing, if I could just boil it down, is that by putting transgender rights under this rubric of sex, which is covered by the ERA, it somehow compromises what the ERA was supposed to do because it lowers the threshold for what? That's my question.
Yes, and it is a little complicated, but you just set it up perfectly. Under the word sex, with regard to the current Constitution, women are only second-class people, which means we get second-class enforcement of rights under a standard of judicial review called intermediate scrutiny. Basically, if I can describe it, it means that if you go to court claiming to have suffered discrimination, the court is allowed to review it under intermediate scrutiny and therefore allow a lot of discrimination by the government to be tolerated. If we were at the top, which is where equality and the ERA would take us, which is what's called strict scrutiny, no discrimination is allowed, or if it is, it's a small amount. So
and the difference between the two has to do with the what's called immutability of the category, right? I mean, and I guess that's what I guess I'm trying to get at, is that once you assume or say legally that sex is not predetermined, that it's mutable, right, you end up with this lower level of protection.
Again, a really important point. Thank you for emphasizing and clarifying, because it's a little bit layered in this sense. Women have been fighting for the ERA because it bumps us up from intermediate scrutiny to strict scrutiny, but the Supreme Court has said we only get bumped up if two things happen. One, if the ERA is put into the Constitution, and two, if women are immutable, meaning non-changeable, meaning you cannot change your sex from male to female or vice versa. The Supreme Court in the 70s issued two rulings where it declared that sex is immutable. It is like race, determined at birth, and can never be changed. So we already had that piece one. Now all we needed was the ERA. Well, guess what happened? Over time, the transgender movement created a collapsing in the law, a collapsing space between sex and gender. And of course, being transgender means your gender is mutable, not your sex, but your gender. But because all of this is happening in law under the definition of sex, and because the Skrmetti case is poised to declare gender is mutable, because how could you not if you're a trans person? And Justice Alito asked at oral argument, but couldn't a person be female today, male tomorrow, and female again the next day? Answer, of course, that is per se mutability. Because mutability is now about to be determined by the Supreme Court under the word sex, women become mutable by legal definition, even if not by biological reality.
Right.
That kills the ERA forever. Doesn't matter what amendments we add to the Constitution. Thanks to the Skrmetti case, because women are now going to be under the definition of a mutable characteristic, we can change the Constitution all we want. The Supreme Court will have authority under Skrmetti to say mutability means you never deserve strict scrutiny.
Wow.
Mutability is the key, and it's the Biden Department of Justice that set up the destruction of the ERA and the devastation to women's fight for equality by filing the Skrmetti case in the first place and then arguing to the Supreme Court about mutability and not even asking for strict scrutiny. That's another piece, Andrew, that's really important.
Well, you know, we're just about out of time, Wendy. I really want to thank you. Just a yes or no answer. Do you think we'll see an ERA in our lifetime?
It doesn't matter. That is the
wow. That's
The
interesting.
point of my article.
Yeah.
Even if the ERA is valid, it doesn't matter because women have become mutable under Scrimetti. That's the way Biden destroyed the ERA. And the Supreme Court is going to say that. In the next year or two, they're going to rule in a decision that it doesn't matter if Biden had the authority to declare the ERA valid, because even if it is valid, it doesn't matter. Women cannot have strict scrutiny because they are now mutable.
Well, Wendy Murphy, fascinating stuff. Really glad that you came on the program today. I'm Andrew Walworth. You've been listening to Real Clear Politics on Sirius XM. We'll be back tomorrow. Hope to see you then. Have a great evening.